Okay, welcome friends. Today the judgment is of Omaxe Chandigarh Extension Developers Private Limited before the authority, RERA Punjab. The date of decision is 19th of May 2022. Let's read the judgment which you see on the screen. It's a complaint filed to the authority under section 31, read with the rules 37 of Punjab RERA rules. Now, previously it was filed before the adjudicating officer and then the issue of jurisdiction came up. So as you all know, the jurisdiction issue has now been decided by the Supreme Court in New Tech Promoters and Developers case. So that's the first para that has been quoted here. Now further, the second para covers the facts of the case. How much was the total amount agreed and how much is paid by the complainant. So the amounts are quoted here, around 64 lakhs total amount and 58 something odd amount has been paid till 2019. So the stipulated date of possession was 42 months plus 6 months of grace, which comes out to be May 2018. And since despite of 5 years lapse, the project has not been completed and the possession has not been delivered to the complainant. Thereafter, the complainant sought refund of the entire amount along with interest. So further in para 3, the court is quoting the reply of the respondent builder. First objection that was taken before the jurisdiction, which is now settled. So that's no longer an issue. Now further, the possession date has been quoted here, as all builders take this plea that the payments are in default. So again this was taken up, but you have to prove it through the documents on record whether there was payment default or not. And further they have taken this new exception that the working days will exclude Sundays and bank holidays and other government holidays. So this was a kind of a new objection placed by the builder. Now further they have quoted that agreement of sales. They have quoted particular paras wherein they say that the interest won't be applicable to them as per the builder-buyer agreement. Now further they say with their terms and conditions of the agreement, which are usually one-sided with the builder, that the possession due date has to be July 2021, read with the Act of the Authority, RERA Act, section 19(3). And last objection they have taken up is of the arbitration clause, that the agreement has arbitration clause, the complainant has to take the relief under that only. Now the complainant filed rejoinder also, that is a rebuttal to the reply of the builder. In that the court has taken this on record. Further, in para 5, the observations of the court start, that the amount is admitted, whatever has been paid, the possession has not been delivered and the last installment is due. So till date the offer of possession has not been made. The court has observed this in their order. Now further, coming on to the merits of the case, the court has discussed first part, whether the stipulated period will exclude government holidays and bank holidays and Sundays. So the objection has already been taken up before other courts as well, which can be State Commission of Punjab as well. They have quoted a judgment of 2019 wherein the court already has settled this issue. Further, the interest part, whether in case of a default the builder is liable to pay interest or not, this has already been settled by the courts. So there was nothing new for the court to decide in this case, as the law is already settled. The judgment which they have quoted is Pioneer Urban Land and Infrastructure Limited versus Govind Raghavan civil appeal number of the Supreme Court, wherein they have decided that the builder is liable to pay interest in case they are at default. Further, the objection they have taken is on account of COVID-19. Already the authority has accommodated builders. They have given an extension of 6 months, but to those projects which are already ongoing and their possession date is not have yet come. But this is a case where the possession date was already in 2019. So this case is not covered, having that plea that the condonation of delay, they are not liable to accept this. So the extension is also without merit in this case. Now further, the arbitration clause, as it has been seen in various judgments of the RERA Punjab Authority, that RERA is an additional remedy. Arbitration is no bar for filing cases RERA. So this again has no merit in the eyes of the authority. So this argument also goes. Now further, the next argument that they have taken is that The RERA registration which the builder has done shows a different date for the date of possession, and they will be getting a relief from this. So this has already been settled. Whatever agreement you have done previously, you have to obey that. The RERA registration date won't apply in this case. The judgment is of Neel Kamal Realtors Suburban Private Limited versus Union of India. So this is one of the most quoted judgments in RERA, wherein the registration date doesn't have any bearing on the agreement signed prior to RERA. Again, the same has been quoted in the Supreme Court judgment of Imperial Structures Limited versus Anil Patni and others. So both of these judgments are being quoted again and again for the merits of the complainants and home buyers, that the date won't have any reference or bearing, whatever date builder is giving on the registration. Now further, all the decisions taken up by the Supreme Court, this is a binding law, so the authority very well has noted it and put down in their order. And in view of all these orders and reasoning found, the authority has now directed to refund the amount the complainant has paid along with interest, and the rate is of the SBI MCLR plus 2%, which is as per the Rule 16 of the RERA Rules 2017. So this is a judgment wherein the refund was granted to the complainant along with the interest, and the case was disposed of with the authority. So this is how the cases are being fought against the builders, and on these grounds the courts are granting relief to the complainant. So hope this helps, and do subscribe to my channel for more information regarding these judgments which are coming up. And if you have any queries or question, you may post it at my website legalseva.net. So thanks for watching, and please do come to my channel again. Bye.